Can wearing too many hats kill you? It did for Mr. Lee. He was a shareholder, a director, and at the same time an employee of his own company, Lee's Air Farming. He wore all those hats at once, and one day, while flying the company plane, he crashed. When his widow claimed workers' compensation, the insurers argued it was nonsense. How could a man be both the master and the servant? How can you employ yourself? Welcome to this summary of English company law and critical updates for 2025. This podcast was prepared by Dr. Yannis. Have a look around his YouTube channel, especially if you're preparing for the SQE. Want to know what happened to Lee's widow? She won. The Privy Council ruled that the company was a separate legal person. That meant Mr. Lee really could be boss and worker at the same time. That's the power and the strangeness of separate legal personality in company law. Let's get into it a bit deeper. We will begin by examining the core tenets of corporate personality and limited liability, the very bedrock upon which UK company law is built, and the exceptional circumstances in which the courts will disregard these principles. We will then navigate the practicalities of forming a company and the revolutionary changes being implemented that transform the role of the state in corporate transparency. Following this, we will dissect the internal dynamics of corporate governance, focusing on the division of power between directors and shareholders and the evolving standards of best practice. A central part of our discussion will be a detailed investigation into the duties and liabilities of directors, a subject that has been reshaped by recent, landmark judicial decisions and groundbreaking legislation. Finally, we will consider the position of the owners, the shareholders, their rights, the legal avenues available to them when those rights are infringed, and concluding with a look towards the future horizon of corporate reporting. This journey will incorporate the most current legislative reforms and case law up to the autumn of 2025, providing a nuanced and up-to-date understanding of this vital area of law. The decision to establish a business in the United Kingdom presents an entrepreneur with a critical choice of legal structure. The options range from the simplicity of a sole trader to the collaborative frameworks of a traditional partnership or a limited liability partnership known as an LLP. However, the most prevalent and economically significant vehicle for conducting business is the limited company, governed principally by the Companies Act 2006. The company is the primary legal form for organizing and running commercial enterprises, employing more individuals and generating more wealth in the UK economy than any other organization. The enduring appeal of the corporate form is rooted in two fundamental principles that were decisively established in the Victorian era: separate legal personality and limited liability. The genesis of this modern framework can be traced back to the Joint Stock Companies Act 1856, which introduced a simple registration procedure for incorporation. Yet it was the landmark House of Lords decision in Solomon v. Solomon and Company Limited in 1897 that cemented these concepts into the bedrock of UK company law. In that case, the court ruled unequivocally that a company once legally incorporated is a distinct legal person, separate from its owners, the shareholders, and its managers, the directors. Mr. Solomon, who had sold his business to a company he had formed and in which he was the majority shareholder, was found not to be personally liable for the company's debts when it became insolvent. This established the inviolable principle of the corporate veil, a metaphorical barrier separating the company's legal identity and obligations from those of its members. The direct and powerful commercial consequence of this principle is limited liability. This concept protects the personal assets of shareholders from the company's creditors, limiting their risk to the amount they've invested in the company's shares. This protection has been a profound catalyst for investment in enterprise, encouraging capital aggregation and risk-taking by assuring investors that their personal wealth is not at stake should the business fail.
While the principle of separate legal personality is the cornerstone of company law, the judiciary has long recognized that this powerful legal fiction can be abused. Consequently, a narrow and exceptional doctrine has developed, allowing courts to pierce the corporate veil and disregard the company's separate identity. Historically, this power was exercised in cases where a company was used as a facade or a sham to evade existing legal obligations. Seminal cases such as Guildford Motor Company Limited v. Horn from 1933 and Jones v. Lipman from 1962 provide classic illustrations. In Guildford, a former employee set up a company to circumvent a non-compete clause in his employment contract, an act the court deemed an abuse of the corporate form. Similarly, in Jones, a company was used as a cloak to avoid the completion of a property sale contract. These early cases established that the courts would not permit the statutory privilege of incorporation to be used as an instrument of fraud or to frustrate the enforcement of legal duties. However, the precise scope and rationale for this judicial power remained uncertain for many decades, leading to a body of case law that was often described as inconsistent and unprincipled. This uncertainty was decisively addressed by the Supreme Court in the landmark 2013 case of Prest v. Petrodel Resources Limited. In his leading judgment, Lord Sumption undertook a comprehensive review of the doctrine and sought to establish a clear, principled basis for its future application. He drew a critical distinction between what he termed the concealment principle and the evasion principle. The concealment principle applies when a company is used to hide the identity of the real actors, but it does not involve piercing the veil. Instead, the court looks behind the company to discover the facts that the corporate structure is concealing. The evasion principle, by contrast, is the true and, according to Lord Sumption, the only basis upon which the corporate veil can be pierced. This principle is engaged when a person is under an existing legal obligation or liability which they deliberately evade or whose enforcement they deliberately frustrate by interposing a company under their control. In such specific circumstances, the court may pierce the veil, but only for the purpose of depriving the controller of the advantage they would otherwise have obtained by using the company's separate personality. The judgment in Prest emphatically confirmed that piercing the corporate veil is a remedy of last resort, to be applied only when all other more conventional legal remedies have failed. The subsequent application of this restrictive test, for instance in the enforcement case of Akhmedova v. Akhmedova, has demonstrated that the evasion principle can be satisfied, but only in clear cases where a corporate structure is actively used to frustrate the execution of a pre-existing legal obligation, such as a court judgment. The legal framework therefore exhibits a profound and consistent policy preference for upholding the corporate veil. This is not a recent judicial fashion, but the culmination of over a century of legal thought that views the certainty and predictability of the corporate form as essential for commerce and economic growth. The decision in Prest was a deliberate and forceful restriction of the doctrine to its narrowest possible common law roots, explicitly rejecting broader notions of justice as a basis for intervention. It demonstrates a continuous judicial thread. The systemic benefits of a predictable corporate structure are deemed to outweigh the occasional injustice caused by its rigid application. The doctrine exists to prevent the abuse of the corporate form, not to reallocate commercial risk. Looking forward, the landscape for applying this principle may be subtly altered by new legislative reforms. The evasion principle from Prest requires a claimant to show that a person deliberately interposes the company under their control to evade an obligation. Historically, proving this control could be a significant evidential challenge, particularly with complex international structures or the use of nominees. However, the Economic Crime and Corporate Transparency Act 2023 introduces a mandatory identity verification regime for all company directors and persons with significant control, or PSCs. This will create an unimpeachable public record of who ultimately owns and controls a UK company. Consequently, a future claimant seeking to pierce the veil will no longer need to expend significant resources proving who the controlling mind is. This will be a matter of public record at Companies House. While the stringent legal test from Prest remains unchanged, this reform lowers a significant practical barrier, enhancing a claimant's ability to meet the test by making the facts required to satisfy it more readily available.
Transitioning from the foundational principles to the practical realities of corporate existence, the process of forming a company in the UK has historically been straightforward, a feature codified in the Companies Act 2006. The Act streamlined the incorporation process, establishing that a company's primary constitutional document is its Articles of Association, which function as a statutory contract between the company and its members, and among the members themselves. The Memorandum of Association, once a detailed charter of the company's objects, now serves the simpler purpose of recording the subscriber's intention to form a company. This framework, designed for ease and accessibility, is now undergoing its most significant overhaul in a generation. The Economic Crime and Corporate Transparency Act 2023, often referred to as ECCTA, represents a landmark legislative shift, fundamentally altering the nature of corporate registration and compliance in the UK. The Act's primary purpose is to combat economic crime, enhance corporate transparency, and improve the integrity of the information held at Companies House. This legislation marks a fundamental philosophical change in the role of the state in corporate formation. Companies House, for decades a largely passive repository of information, has been transformed into an active regulator and a key gatekeeper in the UK's anti-money laundering and economic crime infrastructure. This is not merely an administrative update, but a radical departure from the previous model, which prioritized ease of doing business, a feature that was unfortunately exploited for illicit purposes, damaging the UK's international reputation. The new objectives for the Registrar of Companies now explicitly include a duty to seek to prevent companies from being used for unlawful activities. To achieve this, the Registrar has been granted extensive new powers. These include the authority to query and challenge information that appears incorrect or inconsistent, to request supporting evidence, to reject filings, and to remove information from the register more swiftly. Furthermore, new data-sharing gateways have been established, allowing Companies House to proactively share information with law enforcement and other government departments, positioning it as a frontline intelligence and enforcement agency. The practical manifestation of this new regulatory philosophy began with a raft of changes implemented from 4th March 2024. All companies are now required to maintain an appropriate registered office address, which must be a physical location where documents can be delivered to a person acting on behalf of the company, and an acknowledgement of delivery can be obtained. The use of PO box numbers is no longer permitted. Companies must also provide a registered email address to Companies House for official communications. Furthermore, every new company must now include a statement confirming it is being formed for a lawful purpose, and existing companies must make a similar confirmation in their annual confirmation statement. At the heart of the e-sector reforms is the introduction of a mandatory identity verification regime, a measure designed to make it significantly harder for individuals to use fictitious identities to register and control companies. This requirement will apply to all new and existing company directors, all persons with significant control, that's PSCs, and members of LLPs. The implementation is being phased. A voluntary verification system commenced on 8th of April 2025, allowing individuals to get ahead of the requirements. The regime will become compulsory from 18th November 2025 for all new directors and PSCs of newly incorporated companies, and for all new appointments to existing companies. For existing officers, a 12-month transition period will commence from this date, during which they must verify their identity, with the deadline often linked to the company's next confirmation statement filing date. The consequences of non-compliance are severe. It will become a criminal offence, punishable by a fine, for an individual to act as a director without having had their identity verified. The company itself will also be committing an offence if it allows an unverified individual to act as a director.
Critically, however, to maintain commercial certainty for third parties dealing with the company, the Act clarifies that the acts of an unverified director will not be invalid. To manage this vast new verification task, the ECCTA establishes a new class of regulated intermediary, the Authorized Corporate Service Provider, or ACSP. ACSPs are individuals or organizations such as accountants, solicitors, and company formation agents who are already supervised under the UK's anti-money laundering regulations. These providers can register with Companies House to conduct identity verification checks on behalf of their clients and, in the future, will be the only third parties permitted to file information on the register. This ACSB regime effectively deputizes the private sector in the state's new gatekeeping function. These professionals are no longer just agents of their clients. They are performing a quasi-regulatory role, and they must adhere to Companies House's verification standards and maintain records for 7 years for potential inspection. This creates a new nexus of responsibility and potential liability, as an ACSP can have its status suspended or cancelled by Companies House for failures in its processes. This represents a significant expansion of the compliance ecosystem, where the burden and risk of ensuring the integrity of the register are shared between the state and these designated private sector bodies. Complementing these changes, the ECCTA also reforms company record keeping and filing. The long-standing requirement for companies to maintain their own internal or local registers of directors, directors' residential addresses, secretaries, and PSCs is being abolished. Instead, this information must be filed directly with Companies House and kept updated on the Central Public Register, a move designed to create a single authoritative source of data. Finally, looking ahead, Companies House is transitioning towards a mandatory software-only filing system for annual accounts, which will be phased in over the next few years, eventually removing all other filing options such as paper or web-based services.
The internal governance of a UK company is defined by a constitutional division of power between the board of directors and the shareholders. Typically, the company's articles of association grant the board the power to manage the business, while certain fundamental decisions are reserved for the shareholders to vote on in a general meeting. This dynamic interplay between board authority and shareholder oversight is the central theme of corporate governance. The UK model is characterized by a single, unitary board structure, which comprises a balance of executive directors who are involved in the day-to-day management of the company and non-executive directors who bring external perspective and independent oversight. The presence of strong, independent, non-executive directors is considered a cornerstone of good governance, as is an increasing focus on ensuring diversity in board composition in terms of gender, ethnicity, and experience. For larger listed companies, this governance framework is further supported by a structure of board committees, most commonly an audit committee, a remuneration committee, and a nomination committee, each with specific responsibilities to assist the board. The standards of best practice for corporate governance in the UK are primarily set out in the UK Corporate Governance Code, which is maintained by the Financial Reporting Council. A revised version of the code was published in January 2024 and applies to financial years beginning on or after 1 January 2025. A defining feature of the UK's approach is the comply or explain philosophy. This means that companies to which the code applies must either comply with its provisions or explain in their annual report why they have chosen not to. While this offers flexibility, in practice, institutional investors often exert significant pressure on companies to comply, making deviation a matter for careful consideration and robust justification. The 2024 code introduced several refinements, but its most significant and impactful change is a strengthened focus on risk management and internal controls. This is encapsulated in a new Principle O and, most critically, a new Provision 29. This new provision, which will become effective for financial years beginning on or after 1 January 2026, will require the board to include a declaration in the annual report.
This declaration must state whether the board can confirm that the company's material internal controls, covering financial, operational, reporting and compliance systems, have been effective throughout the reporting period. The board must also describe how it has monitored and reviewed the effectiveness of these controls and explain any material weaknesses identified in the remedial action being taken. This development represents a significant step towards a UK version of the regulatory framework established in the United States by the Sarbanes-Oxley Act, commonly known as SOX. Following high-profile corporate scandals, the US responded with prescriptive legislation requiring direct certification of internal controls by the CEO and CFO. The UK has historically resisted such a rigid approach, but the new Provision 29 moved the governance landscape much closer to the US model by placing a formal, collective and explicit responsibility on the entire board to assure the effectiveness of the company's control environment. This is expected to drive a substantial increase in investment by companies in documenting, testing and gaining assurance over their control frameworks, creating a new and significant compliance burden often referred to as UK SOX. This evolution in internal governance standards creates a powerful synergy with the external transparency reforms of the ECCTA. The two initiatives create a pincer movement on corporate accountability. The ECCTA focuses on the integrity of the public register, providing clarity on who owns and controls a company, which is an external accountability mechanism. The 2024 code, in contrast, focuses on the board's oversight of the company's internal systems for managing risk, which is an internal accountability mechanism. These two regimes are mutually reinforcing. A failure identified through one could easily trigger scrutiny under the other. For instance, a fraud that occurs due to weak internal controls, representing a failure under the code, might also lead to false information being filed at Companies House, constituting a breach of the ECCTA. This dual pressure from both external transparency requirements and internal assurance demands significantly raises the stakes for directors and boards, creating a more holistic and robust framework for corporate accountability. The individuals entrusted with the management of a company, the directors, are subject to a comprehensive set of legal duties designed to ensure they act in the company's best interests. These duties, derived from centuries of common law and equity, were codified in the Companies Act 2006, specifically in sections 171 to 177. While the Act provides a statutory statement of the general duties, it is not an exhaustive code, and the underlying common law principles remain relevant for interpretation. The first of these duties under Section 171 is the duty to act within the company's powers, meaning directors must comply with the company's constitution and exercise their powers only for the purposes for which they were conferred. This prevents directors from using their powers for improper purposes, such as issuing shares solely to dilute the voting power of a particular shareholder, as established in the case of Howard Smith Limited versus Ampol Petroleum Limited. The cornerstone of directors' duties is found in Section 172, the duty to promote the success of the company for the benefit of its members as a whole. This duty encapsulates the concept of enlightened shareholder value, requiring directors to act in the way they consider, in good faith, would be most likely to achieve the success. In doing so, they must have regard to a non-exhaustive list of factors, including the long-term consequences of their decisions, the interests of employees, the need to foster relationships with suppliers and customers, and the impact of companies' operations on the community and the environment. For many years, the test for compliance with this duty was considered to be largely subjective, focusing on whether a director genuinely believed their actions were in the company's best interests. However, this understanding has been fundamentally reshaped by the Court of Appeal's crucial judgment in 2025 in Saxon Woods Investments versus Costa.
In this case, a director had deliberately caused the company to breach a shareholders' agreement and concealed this from the board, but the High Court initially found that he had not breached his duty because he sincerely believed his actions would ultimately lead to a better outcome for the company. The Court of Appeal emphatically overturned this decision. It ruled that the duty to act in good faith under Section 172 incorporates an objective standard of honesty. A director's subjective belief is no longer a complete defense. The court will also ask whether the director's conduct was objectively honest by the standards of ordinary decent people. A director who deliberately misleads the board cannot justify their actions by claiming that the shareholders might thank me in the long run. This decision significantly strengthens the duty, making it clear that good intentions cannot excuse objectively dishonest conduct. The other codified duties include the duty to exercise independent judgment under Section 173, the duty to exercise reasonable care, skill and diligence under Section 174, which has both an objective and a subjective element, the duty to avoid conflicts of interest under Section 175, the duty not to accept benefits from third parties under Section 176, and the duty to declare an interest in a proposed transaction or arrangement with a company under Section 177. Beyond these general duties owed to the company, the common law has also developed a specific duty that arises when a company faces financial distress. This is the duty to consider, or in certain circumstances act in, the interests of the company's creditors. The scope and trigger point for this duty were the subject of considerable legal debate until the Supreme Court provided definitive clarification in its 2022 decision in BTI 2014 LLC v. Sequana SA. The court confirmed that this duty to creditors is engaged when the directors know or ought to know that the company is insolvent or bordering on insolvency, or that an insolvent liquidation or administration is probable. It is a sliding scale. The more perilous the company financial position, the more weight directors must give to the interests of creditors, which can eventually become paramount. This principle was subsequently applied in the 2023 High Court case of Hunt v. Singh, reinforcing its importance for directors navigating the zone of insolvency. The landscape of corporate liability has been further and profoundly altered by the ECCTA, which introduces a new corporate criminal offence of failure to prevent fraud. This offence, which comes into force on 1st of September 2025, represents a significant expansion of corporate criminal liability in the UK. The offence applies only to large organisations, defined as companies or partnerships that meet at least 2 of 3 criteria: more than 250 employees, more than £36 million in turnover, or more than £18 million in total assets. An in-scope organisation will be criminally liable if an associated person, a broad category including employees, agents, subsidiaries, or anyone performing services for the organisation, commits one of a specified list of fraud offences with the intention of benefiting the organisation or its clients. The organisation can be liable even if its senior management had no knowledge of the fraud. The only defence available to a company is to prove that at the time the fraud was committed, it had in place reasonable fraud prevention procedures. The Home Office has published detailed guidance on what constitutes such procedures, based around 6 key principles: top-level commitment from senior management, a thorough and documented risk assessment, the implementation of proportionate risk-based prevention procedures, appropriate due diligence on associated persons, effective communication and training, and ongoing monitoring and review of the procedure's effectiveness. The combined effect of the Saxon Woods judgment and this new failure to prevent fraud offence marks a fundamental shift in the assessment of both directorial and corporate conduct. The focus is moving decisively from a subjective standard based on a director's internal state of mind to an objective and systems-based one. For a director's personal liability under Section 172, good intentions are no longer a sufficient defence against conduct that is objectively dishonest. For corporate criminal liability, the new offence imposes a form of strict liability, from which the escape is a defence based on the objective reasonableness of the company's preventative systems.
This makes compliance more demanding but also more predictable, as the standard is now based on externally verifiable evidence, demonstrable honesty, and robust documented procedures.
Furthermore, while the failure to prevent fraud offence itself applies only to large organisations, the reasonable procedures defence is set to become the new gold standard for corporate governance in practice for a much wider range of businesses. This will be driven by powerful market forces. Auditors assessing a company's control environment, insurers underwriting directors' and officers' liability policies, and investors conducting due diligence will all likely use the Home Office guidance as a benchmark for best practice. Moreover, smaller companies operating in the supply chains of larger organizations may find themselves contractually required to implement similar procedures to protect their larger partners from liability. As a result, the 6 principles of the guidance will become a de facto standard of good corporate governance across the commercial landscape. The owners of the company, the shareholders or members, occupy a crucial position within a corporate structure. While they delegate the day-to-day management to the board of directors, they retain ultimate control through a set of fundamental rights enshrined in the Companies Act 2006 and the company's Articles of Association. These rights include the right to receive a copy of the company's annual accounts and reports, the right to receive dividends when declared, and, most importantly, the right to vote at general meetings. Shareholder decisions are made by passing resolutions. An ordinary resolution requires a simple majority of votes cast, more than 50%, and is used for matters such as the appointment or removal of directors. A special resolution requires a supermajority of at least 75% of the votes cast, and is reserved for more fundamental changes to the company, such as altering its Articles of Association or changing its name. When the actions of the directors or the majority shareholders cause harm to the company or are oppressive to a minority, the law provides several remedies. The starting point is the principle of majority rule, established in the 19th century case of Foss v. Harbottle, which holds that for a wrong done to the company, the proper claimant is the company itself. This rule prevents the multiplicity of lawsuits by individual shareholders. However, this principle could lead to injustice if those in control of the company are the ones committing the wrong and refuse to let the company sue. To address this, the Companies Act 2006 provides 2 key statutory exceptions. The first is the derivative claim under Part 11 of the Act, which allows a shareholder to seek the court's permission to bring a claim on behalf of the company against a director for a breach of duty. The second and more commonly used remedy is the unfair prejudice petition under Section 994 of the Act. This is a powerful and flexible tool that allows a member to apply to the court for relief on the grounds that the company's affairs are being conducted in a manner that is unfairly prejudicial to the interests of the members generally, or some part of the members, including the petitioner. The concept of unfair prejudice is broad and can cover a wide range of conduct, from breaches of the Articles to the frustration of legitimate expectations in quasi-partnership companies, as explored in cases like Ebrahimi v. Westbourne Galleries Limited and O'Neill v. Phillips. A significant development in the dynamic between companies and their shareholders occurred in 2025 with a landmark judgment from the Privy Council in Jardine Strategic v. Oasis, a decision which, by a special direction, is binding on the Court of England and Wales. This case conclusively abolished the long-standing but often criticised shareholder rule concerning legal professional privilege. This rule had for over a century created an exception to privilege, preventing a company from withholding legal advice to its shareholders in disputes concerning their rights as shareholders, unless that advice was sought for the dominant purpose of litigation against them. The Privy Council found the rule to be an anomaly that was inconsistent with the fundamental principle of separate legal personality established in Solomon. The court reasoned that the idea of a joint interest between a company and all of its shareholders was a serious oversimplification that ignored the commercial reality that the interests of different shareholder groups and of the company itself are often not aligned. The practical implication of this decision is profound. It is now significantly more difficult for shareholder litigant to gain access to a company's privileged legal advice. This strengthens the company's position in disputes and reinforces the board's managerial authority. It signals a clear judicial preference for protecting the integrity of the board's decision-making process, which includes the ability to seek candid legal advice without fear of it being used as a weapon by a dissenting shareholder faction. It represents a significant recalibration of the balance of power in shareholder litigation, favouring the preservation of corporate autonomy.
Looking to the future, the next major evolution in UK company law is already taking shape in the domain of sustainability and non-financial reporting. There is a growing recognition that a company's long-term value is intrinsically linked to its management of environmental, social and governance, or ESG factors. In response to this, and to align with global trends, the UK government is in the process of developing a new framework of UK sustainability reporting standards known as UKSRS. These standards are based on the new international baseline set by the International Sustainability Standards Board's IFRS S1 and S2 standards, which cover general sustainability-related financial disclosures and specific climate-related disclosures, respectively. A consultation on the draft UK standards was launched in June 2025, with the aim of making finalised standards available for voluntary use in late 2025, before any future decisions are made on mandating their use for UK companies. This move towards mandatory, standardised ESG reporting creates a new and significant area of litigation risk, particularly viewed alongside the new failure to prevent fraud offence. The new offence covers false statements by company directors and fraud by false representation. The official Home Office guidance explicitly uses the example of misrepresenting a company's ESG credentials, so-called greenwashing, to attract investment as a potential fraud that could be intended to benefit the organisation. This creates a direct link between the new sustainability reporting regimes and the new corporate criminal liability regime. A company that makes a misleading statement in its mandatory sustainability report could find itself not only facing regulatory action or civil claims from investors, but also potentially committing a base fraud offence. If that misrepresentation was made by an associated person for the company's benefit, the company itself could be criminally prosecuted for failing to prevent fraud if it lacks reasonable procedures to prevent such misstatements. This convergence of reporting standards and criminal liability forges a new category of risk, governance-based misrepresentation, and ensures that the accuracy and integrity of a company's ESG disclosures will become a matter of critical importance for boards and their legal advisors in the years to come. Want to know more about company and business law? Have a look around Dr. Yannis' YouTube channel. Thank you, and see you next time.